We're on the very final day before the enforcement dimensions of our Data Protection Act kicks in. Tomorrow will be the 1st of December 2023. So, I'm sure that there are some questions from the business community in terms of how do we prepare for this statute in terms of ensuring that we are adhering to the compliance dimensions. Well, the Data Protection Act was passed in 2020, as you know, was Act 7 of 2020, and it has several parts to the legislation, covering from the preliminary aspects in terms of the definitions that are employed throughout the legislation. It speaks to the rights of the data subjects and others. It also covers the requirements for data controllers. It covers the standards for processing personal data. And it speaks to exemptions to data protection standards or to disclosure to data subject requirements. There are also there's also coverage of enforcement under the statute. The statute actually has teeth. There are penalties, which I will get into further down in the presentation. It also covers some miscellaneous and general applications, uh, such as what you'd expect to come up in the regulations when they are available. So most importantly, although this is a 2020 statute, the compliance, well, for want of a better description, the grace period that was allowed um, under the statute was that we had until tomorrow morning to get compliant with the requirements of this act. And I should also um, mention that my presentation is not from a legal perspective, but purely from the perspective of the knowledge worker. Right? I'm a knowledge professional, and so my presentation is made from the perspective and not from a legislative or legal perspective. In terms of definitions for privacy or personally identifiable information, there are some definitions I like to go through. In terms of what personally identifiable information is, and you see that in similar legislation, such as you'd see in the GDPR, the Generalized Data Protection Regulations, and the Consumer um, Protection Act of California, and other similar privacy related legislation, is that personally identifiable information would be um, details such as your name, for one, you know, your social security number in terms of the United States. In our specific jurisdiction, that might be your taxpayer registration number, your social security number, and such unique identification, your passport number. Biometric records are deemed to be sensitive information. I'll get into that further down. But these all constitute um, information that is deemed to be personal, right? Personal data in terms of becoming part of or streamlined into business, uh, procedures and documentation was popular as a result of the mainly through the European Union's Data Protection Directive, which is the precursor to the GDPR, and that was Directive 9546 EC, which defined personal data as information which can identify a person via an identification number or factors specific to physical, such as, for example, a tattoo, physiological, mental, economic, cultural, or social identity, right, are deemed to be personal data under that statute. And that language carried over into several other types of statutes such as HIPAA, Health Information and Portability Personal Act. HIPAA is very popular in the United States in terms of health information. You'd find that similar um, narrative is used in FERPA as well, and so they became more mainstream. In terms of our local statute, within our Data Protection Act, um, we would have made similar definitions, under the Part 1 of the statute. Um, as you know, on December 1st, 2021, Jamaica appointed its first information commissioner through Ms. Celia Barkley, and that commenced the process towards getting compliant with the legislation. So that was our transitional period, which ends today, right? In terms of the Office of the Information Commissioner, this is the main regulator recognized under the statute, under Part 1, Section 4 of the Act. And the duties and responsibilities of the office includes, first of all, monitoring the compliance of the data collectors and data controllers with respect to the Act and any other regulations that will be forthcoming from, the Act. Also, most importantly, providing advice to the relevant minister on any matter relating to the operation of the Act or otherwise for the protection of personal data. The office is also charged with promoting the observance of the requirements under the Act and the following of good practice by data controllers. So, um, as you know, this is a new it's a new space for us, in terms of um, implementing and administering a privacy regime that is nationwide. And so, therefore, best practices from other jurisdictions would be a factor in terms of defining good practices. The office is also charged with disseminating information on the Act and advising, persons, especially data subjects, of the rights inherent under the statute, as well as how, matters such as redress or claims can be addressed or approached through the office. The office is also charged with preparing and disseminating guidelines under the Act. So you would have seen within the newspapers, full page ads and so forth. They're embarking upon a campaign to bring more awareness to the acts, the rights and facilities under the Act. Also, the office has a role in terms of any matters that are before the court relating to personal data and the processing of personal data, or the enforcement of any provisions of the act, other than proceedings for the prosecution for an offense. In terms of uh, personal data, I would have given before some definitions, but just to give you an appreciation in terms of the scope of the statute, this covers personal data relating to either a living person or natural person, or a person that's been deceased for less than 30 years, who can be identified from that information alone or from that information or other information in the possession of or likely to come into the possession of the data controller, and which includes any expression of opinion about that individual or any indication of the intents of the data controller or other persons in respect of that individual. I had mentioned before that it also had a carve out for sensitive personal data, and under our Data Protection Act, sensitive personal data includes inter alia genetic data or biometric data, um, filiation, racial or ethnic origin, political opinions, philosophical beliefs, religious beliefs, or other beliefs of a similar nature, membership in any trade union, physical or mental health or condition, your sex life, or the alleged commission of an offense by the data subject, or any proceedings for any offense alleged to have been committed by the data subject. So, one example that I can pull from another jurisdiction, which is the United States, is that you have the equal employment opportunities good practice, whereby if you're applying for a job, you're allowed to opt out of, for example, declaring your gender, declaring your religious, beliefs, declaring your sexual orientation, and so forth. Um, that is perhaps something that we could employ as a good practice whenever we're looking at employing people, at least in the first instance in the public service, because it's a more um, and more institutionalized, um, I suppose, sector than the private sector would be. In terms of personal data, again, this personal data can be processed where necessary for the administration of justice, exercise of any functions conferred by or under any enactment, or conditions for processing personal data in accordance with the first standard. And I'll get into the first standard, further down. But essentially, this deals with consent of the data subject. The data subject has to consent to having their data being processed, right? But if it's within the public interest, that right can be waived based on the circumstances. I know that we have the practice of displaying voter registration identification cards, TRNs, driver's license, etc. If, for example, the owner of said documents inadvertently left them in a public space, they lost them, they found a driver's license on the ground, they would normally put it on the glass. I have it displayed there. That actually would not be in keeping with good practice under the Data Protection Act, right? So, uh, arrangements such as what we were observing during COVID, such as contact tracing, which involve, for example, a book with people's names, personal information such as where they live, their telephone numbers, etc., would be a no-no under the Data Protection Act. Okay, so these things are um, sensitive personal data. There's been a lot of confusion between what a data controller is and a data processor. Essentially, a data controller is defined under the Act as any person or a public authority who either alone or jointly or in common with other persons determine the purposes for which and the manner in which any personal data are or are to be processed, and where personal data is processed only for purposes for which they are required under any enactment to be processed. The person to whom the obligation to process the data is imposed by or under that enactment is for the purpose of this act a data controller. So essentially, who gets to decide what happens with the personal data is the data controller. Literally, the entity or person that controls what happens to the information that is reposed, right? So it could be a government ministry, department, or agency, right? And we know some of them that collect very personal information. We have um, the Registrar General's Department, which from tomorrow becomes the National Identification and Registration Authority, the NIRA, under the NIT statute. And I'll get to some of the related dimensions, in a further slide. But the Jamaica Constabulary Force also takes a lot of personal information. The constable has to interact with the public, and the first thing that they'll do typically is to ask for some kind of identification. So that's your driver's license or your voter registration, or even your passport. And PICA, the Passport Immigration and Citizenship Agency, processes a lot of very personal and sensitive information. Where you live, your, um, you know, how many persons in your household, your travel details, etc. If you're registered in a company, you also share very personal information. These are all data controllers, but they can also um, farm out some of the responsibilities in terms of processing to a data processor. They still get to decide what happens to the information, but a data processor is any person other than an employee of the data controller who actually processes the data on behalf of the data controller. So custodianship would still be with the data controller, but say for example, um, companies that choose to use like a hiring firm may want to provide them with the authority to process that personal data on their behalf. So there may actually be consultants coming in to do specific, activities on behalf of the data controller that are actually done through a data processor. So you have an entity such as courts, NCB, or any of the other banks that, for example, with those customers that fall in default, they basically send over that personal data, their payments, where they live, their contact information, etc., to a data processor to ensure that some kind of redress can be exercised so they can actually collect the monies owed. Similarly, JPSCO may use third party um, service providers such as Bills Express and such to pay bills. And similarly, the same with Digicel, Flow, etc. You're sending a lot of personal information through these entities, but the objective is to pay a bill within one of these entities. So you're paying a bill that rests with the data controller, but through a data processor, right? So I hope that that's been clarified. In terms of the data protection officer, the data protection officer is required under the statute, and this person is essentially defined as uh, someone who is qualified, must be a qualified person, and this person should be more or less committed more to the rights of the data subject than to the entity that he or she works with. So this is something that's required, especially of data controllers that are public authorities. So that goes back to your PICA, RGD, etc. And if the data controller also has to process a lot of data, large data on a wide scale, they're also required to ensure that a data protection officer is put in place. Similar to the requirement to have an access officer if they're a public authority to service the requirements of the Access to Information Act, right? And they're also required, especially if they're, public authorities or data controllers that process what they constitute to be sensitive personal data, or even data that relates to criminal activities, such as, for example, um, persons who are trying to um, steal people's identities, take money, etc. That these persons should have a data protection officer in place to report on any breach that might be discovered, and also to ensure that there's a data protection impact assessment shared with the Office of the Information Commissioner. I should have also mentioned earlier that before all of this happens, the data controller should also be registered with the Office of the Information Commissioner, because it's a serious breach if they're processing these huge volumes of personal data without getting permission from the Office of the Information Commissioner. Okay, it's all right. Also, in terms of the rights of the data subjects, there are eight recognized rights under the Data Protection Act. our Data Protection Act. I did mention earlier in the presentation that um, personal data has to be consented in terms of processing by the data subject, and there must be an intent to process this personal data fairly and lawfully, right? So this consent has to be the first rule of the entire process. The second rule is that the personal data should be obtained for specific purposes. So you can't, for example, be collecting personal data for an application for a job, and then you're going to use that same information to do a survey, for example, to find out how many applicants came from St. James versus from St. Andrew. It should be for specific purposes. And as much as possible, there should be adherence to what we call the minimalist approach, meaning that you only take the specific types of information that will be required to do the processing and not ask for, too many details. So, for example, if you are trying to get personal data to say, for example, issue a passport. I'm just using an example. You ought not to be asking for things such as, although they could, depending on the circumstances, let me put a caveat there, but asking them, for example, about their religious beliefs and that kind of thing. Um, that, to the best of my knowledge, should not be a factor in issuing a passport, but I defer to the experts. But as much as possible, you should try and only gather that specific information that you need to process whatever it is that you're providing as a service as a data controller. Data subjects have a right to ensure that their information is accurate, and where necessary that that information is kept up to date. So, for example, they should have some access to the information, barring scenarios where it concerns national security or there's a public interest that outweighs them having that kind of access. So, for example, if it has to do with a public health situation where they are a risk, that information could be withheld from them under the exemptions under the statute, but they should have the right to check that information to ensure that the information is accurate and it's kept up to date. And also, the information should have retention values placed upon them. You ought not to be keeping applications for a job more than, I would say, more than 4 or 5 years, because chances are those individuals would have moved on, transitioned to other jobs, maybe transitioned out of Jamaica, maybe moved over into different sectors. So you should only keep that information for minimum period required to facilitate the processing of the service or whatever it is that the information was collected for, right? And you have to ensure that where it relates to other legislation or regulations that you're in compliance with those. So if it's personal data that's collected around, you know, pension contributions or any other benefit that's covered under another law, you have to ensure that you adhere to all the applicable statutes related to that specific record. And data subjects have a right to ensure, or at least they should be given the reassurance that the personal data will be processed in accordance with these rights, right? The 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 statute mentions, for example, um, the data subject's right not to be subject to automatic or automated processing, meaning, you know, machine um, a machine processing the personal data, because it might be processed inaccurately, or there might be some inherent prejudice in the information that might put that person at a disadvantage. So We have to ensure that the data is processed in accordance with the rights of the data subjects as per these principles. And the personal data should be protected by the appropriate technical and organization measures, such as, for example, ensuring that if it's electronic information or electronic personal data, electronic personally identifiable electronic personally identifiable information should have encryption at the bare minimum, and safeguards such as having to enter credentials to access a device to get into that database. It should allow for auditing to be possible. It should allow for access rights to be set, right? So rights can be assigned to specific users, so unauthorized users cannot access that information. Also, very importantly, there should be some reassurance in terms of training. There should be a policy. There should be coverage in terms of the safeguards under a data protection impact assessment. There should be a data notice in place to tell that data subject what what safeguards are in place for the protection of their information to those that are external to the organization, and the data protection policy and regulations would be relevant to those internal to the organization that are actually doing the processing of the information, right? So the staff member that has to, you know, that has a responsibility of processing this information should recognize that there are penalties if they fall in breach of some of these, requirements. And finally, and most importantly, the personal data ought not to be transferred outside of Jamaica to another territory or jurisdiction without that jurisdiction having adequate or better protection than we have here in Jamaica in terms of um, a privacy framework at the national level. So if it is that we're sending information that's personal and private outside of Jamaica to a country that doesn't have a data protection framework in place, this is actually a breach under these principles. In terms of the other initiatives that I'd mentioned before, the NIDS is one, the Jamaica Eye is another as well, and the Registrar General's Department is another. In terms of the local laws, personal data also covers things such as your image. So facial recognition software under the Jamaica Eye might be something worth considering. We don't currently have CCTV laws in place here in Jamaica, but that's something that could be looked at, I believe, as a good practice through the Office of the Information Commissioner or even from the Ministry of National Security, right? Uh, in terms of NIDS, then it's obvious because the National Identification and Registration Authority, the NIRA, which is the RGD that will transition come tomorrow morning, will be the main repository of personally identifiable information for most Jamaicans, right? And obviously, their frameworks to be put in place are, well, have been covered under the statute, such as I forgot to include that bullet there of the Data Protection Oversight Committee, which is the committee that the Office of the Information Commissioner would report to in terms of ensuring that there is some independent oversight of the OIC in terms of monitoring the performance of the Data Protection Act. Also, uh, I'd mentioned that the the fact that we're collecting all of these very personally identifiable information already, we have to be careful because we live in small societies, and there are a number of initiatives that are around in terms of sharing of information. We know that a lot of the services that are offered by public authorities, right? Especially individuals such as justices of the peace, etc., notary public. Um, they need to have proper records keeping uh, uh, frameworks in place to ensure that they're, again, as per the the principle 7 of the DPA, where you have to have technical and operational frameworks put in place to safeguard the personal data, that at least proper records keeping will be one of the fundamental things that will be in place to ensure that people's personal, data doesn't fall into the wrong hands. So the disposal of said information should be a factor. The collection and storage of it should also be another factor, right? And so there are many arrangements to be put in place in terms of good practices that relates not just to the DPA but to other similar initiatives to ensure that PIIs are not shared inadvertently, um, with people that ought not to have access to same. In terms of the penalties, uh, there and like I said, this statute has real teeth. Um, these breaches can constitute criminal offenses, attracting penalties for both corporations and individual corporate officers. So similar to the Sarbanes-Oxley, law in the United States, where corporate governance is a big feature and which does not lie solely with the CEO, but also in terms of the records manager, the chief operations officer, the head of compliance, etc. There will be specific, um, penalties levied at persons that have direct responsibilities for managing personal data within the organization under the statute. So, in terms of at the corporate level, fines shall not exceed 4% of the annual gross global turnover for the preceding year of the assessment, because under the DPA, you have you have to provide to the OIC, the Office of the Information Commissioner, um, an annual report in terms of any breaches that would have occurred during the period, and also to furnish an annual data protection impact assessment, right? So this is also benchmarked against the Income Tax Act in terms of the annual gross globally. In terms of the individual level, it's set at 5 million Jamaican dollars, which is approximately, if you want to compare the GDPR penalty, 32,000 and 50,000 euros, right? Or or imprisonment up to a maximum of 10 years under the statute, and that's our local Data Protection Act. In terms of GDPR, which is global, right? So an European Union statute becoming globally enforceable. There are two levels similar to us, and we actually look to the GDPR in terms of building our domestic law. And the first is that you can be fined up to 10 million euros or 2% of the company's global annual turnover of the previous financial year, or whichever is higher. And the second fine can go up to 20 million euros or up to 4% of the global annual turnover of the previous financial year. So essentially, it's doubled once you end up being fined for the second time. In terms of overall DPA compliance, I did mention the 8 data principles, which is the consent, the notification as to the reason for the collection, minimalist approach to collection, ensuring that the data is accurate, ensuring that the data is retained for only the minimum period, ensuring that the rights of the data subjects are respected, and that personal data is to be protected, and then finally, that personal data is restricted to Jamaican jurisdiction as much as possible, unless you have the reassurance that the destination jurisdiction has an equally robust framework in place to protect the information that's going to be shared outside of Jamaica. In terms of cost savings, to the company. The solution is going to be based on an electronic setup based on my understanding from the Office of the Information Commissioner. So the registration would be electronically done. So I don't know if they've come up with the instrument as yet for data controllers to be registered, but that's a prerequisite to anything that can be done under the statute by a data controller or a data processor. Um, but this, I am sure, would allow for monitoring to be done. You're able to audit and ensure that you can track the performance of the system. In terms of compliance, the annual reports to the data protection, sorry, to the Office of the Information Commissioner, in terms of the data protection impact assessment by the data protection officer, would also allow for benchmarking to be done. And this is just good corporate governance. The organization, once they're compliant with this statute, should be seen as an institution that's responsible. That should reassure every single customer, every employee, every consultant, every intern that there's some adherence to good practice as as we expect under the regime and to be shared by the Office of the Information Commissioner eventually. There should also be some robust cybersecurity and risk management in place that should provide deterrence to those that may seek to access this personal information unauthorized, So there will be investment, I'm sure, by all of these data controllers to ensure that there will be no risk, or they will reduce the risk rather in terms of breaches or possible breaches. In terms of the literature that will be forthcoming from all concerned, it should be targeted to all visitors, all persons that need to do business with the organization should be able to digest the information around the data protection, um, you know, uh, procedures or safeguards that are available. So the data protection notice, for example, which is front facing, should tell people that use a website or deposit their personal data, their personal identifiable information, that this is what this information is being collected for, this is how it will be treated, and reassure people essentially. All vendors would also be required to sign some non-disclosure agreement, which is standard, to ensure that the information that they come into contact with would not be shared outside of the limited scope of whatever it is that they're required to do that requires the interaction with the personally identifiable information. Staff should have a reassurance through their data protection policies that the information that they submit as a staff member or an intern or consultant or whatever will be treated in a particular manner. And most importantly, the breaches, if any of them should violate said policy, should also be passed on to them, where they accept the the liability, so that they can face punitive measures if they fall in breach. Okay. Most importantly, you want to ensure that there's a strong relationship in terms of the OIC. The Office of the Information Commissioner, as the regulator, should be given the reassurance that the data controller is adhering to the tenets of the statute of the DPA. They should provide regular updates to the OIC in terms of not just the data protection impact assessments that are due annually, but also under the legislation, if it is that there is a discovered breach, you have 72 hours as a data controller to report said breach to the OIC. Okay, so you're required to notify the OIC of the breach, and you're also required to notify the data subject, barring um, the information concerned not falling into the exempted areas of the DPA in terms of whether or not it relates to um, some public safety issue or something around national security or something in a civil or criminal matter. The literature should be easy to use. You want to ensure that the data protection notice is written in language that can be understood easily. Your data protection policy and procedures should also have with it proper training in terms of the staff, and that should be mandatory for everybody that interacts with personally identifiable information. You want to ensure that there is the registration as a data controller with the OIC, and that should have been the first bullet. My bad with that. Uh, you want to ensure that as a data controller, you have appointed your data protection officer. Your data protection officer is essentially your gladiator, right? Not so much for you as the company, but to ensure that that gladiator defends the data subject's rights and ensures that there's full compliance and adherence to the DPA. The data protection impact assessment should cover the range or universe of risks around the data, the personal data that's been interacted with and processed and collected and stored, etc., disposed of, so that the OIC can establish whether or not the data controller is adhering to good practices. In terms of the training and awareness that I mentioned before as part of the data protection policy and procedures, the training and awareness program should, as much as possible, cover the tenets of the Data Protection Act. You want to ensure that the training will be consistent with the at least the 8 data principles that are mentioned on the DPA, and it should be standard. Your data incident reporting mechanism should include not just um, telling people um, that there's been a breach, but what caused the breach. Has the situation been addressed? Did it happen before? You want to ensure that depending on the type of breach, if it's um, electronically stored information, for example, that the ESI has been, you can put in place uh, measures to reduce or eliminate the risk around having any future occurrences. If it's based on a paper-driven process, they have processes in place to ensure that there is no physical access to the information that got violated, and you want to basically reassure the OIC that you have put in place safeguards. And also, the data incident reporting mechanism should also mention whether or not the data subject has been contacted. If not, why wasn't that data subject contacted? Okay? And also, you should have annual reports, and the annual reports would be the compendium of um, breaches that would have occurred within the review period. Also, want to include the data protection impact assessments that would have been submitted to the OIC. Also, should include the details of the data protection officer. So, for registration, I should have also mentioned the data protection, sorry, the data controller's name, address should be, pertinent. It should be, displayed big and bold so that, there's no question as to the entity concerned or to the natural person concerned. And if it is a natural person, the name, address, and other contact details of said, natural person. If you have a data processor, similarly, you want to ensure that you can at least reach out and access this resource, because should you have any questions, this is your in-house subject matter expert on data protection, right? This would then constitute compliance, basic compliance with the DPA. I hope that this conversation was useful. I'm prepared to, to do more of these. It's something that I've been very excited to see developed. I think that this is part of our development process as a nation, where we can then join the rest of the developed world in terms of having these frameworks in place. I can tell you, as somebody that's delved in trade policy, that um, a jurisdiction like the European Union, if we can offer um, similar reassurances, because again, we would have taken a lot from the GDPR. Without having a statute like this in place and having a regime in place, we're not giving the European Union the reassurance that personally identifiable information that comes from their jurisdiction will be safe in our jurisdiction. So I believe that having something like this in place would or should offer more opportunities for us as a country, at least in terms of accessing that market easier now, especially where it involves um, services that would involve interaction with personally identifiable information coming from data subjects from the European Union. Thank you for your attention. I look forward to hearing the feedback, and I wish all those entities that um, are looking at getting registered or would have registered already with the OIC all the very best as we transition to full compliance and you know ensuring that the enforcement dimensions of the DPA would not come back to haunt us. So I'm hoping that this will be of some benefit to somebody out there. And I thank you for your attention. And I'll be looking out for the feedback. Thank you and have a good night.